This is Colin O'Keefe for LXBN TV. Employee social media privacy has become a very big subject over the past year, with states pushing for legislation on this front and employers struggling to strike a balance between protecting themselves and not infringing on employees' rights. Joining me now to discuss each of these topics from Chicago is attorney Scott Schaefers. He is with Cypher Shaw, an author on the firm's blog, Trading Secrets. Scott, first, let's start with the legislation front. What's the latest here? Where do things stand now on the state level, and is it possible that we'll see something similar on the federal level as well?
Morning, Colin. 13 states have passed one form of this privacy legislation or another. The federal law, Congress has not. They've tried twice, but it died in committee. But 13 states have enacted some form of legislation which, to some degree, varying degrees, protect employees and, in some states, university students' privacy rights in their social media accounts. So we, just so you know, we're about to put out this desktop reference to clients and anyone else that wants to take a look. In it, we list the various states that have enacted legislation, what the various features are, what's prohibited, what's permitted, and we talk about some of the legal issues that might arise in litigation in the courts based on this legislation. So, generally speaking, a current employee or a current student in those states with higher education laws, an employer cannot require, and in most states even ask, the current employees or even job applicants for mandatory access to their social media accounts. The employer cannot retaliate against the employees for refusing to provide that access. And in pretty widely varying degrees, there are penalties and remedies for employer violations of it. Our booklet makes that clear and points those out in greater detail.
I see. It's something that employers really need to be careful with, because with this patchwork of state legislation, corporations with offices in different states really face a multitude of different restrictions. So second, what's your advice for companies who are looking to protect themselves, but also make sure they're not infringing on employees' rights as well? How do they strike that balance there?
Well, first and foremost, you should talk to an attorney who knows something about it. That, of course, would be us or some other learned attorneys. But a couple things to point out about this legislation is that most of them only apply to exclusively personal accounts, personal employee accounts. So if the employers have policies or job descriptions which include required maintenance of a social networking account, like a LinkedIn, like a Google+, then it's a good bet that the employers can avoid the reach of the statute. Furthermore, if the employer has information that a security breach occurred, for example, the employee took a customer list and put it on his or her LinkedIn or Google+ account, then the employer has a number of rights under the statute, including investigating that, requiring the disclosure of login information or some other form of mandatory access. And there's many other loopholes that employers can take advantage of, which are written into the statutes, and which may not be written in, but they might be able to take advantage of nonetheless in the courts.
Definitely. There's a lot of gray area with this topic, and then, of course, with all the different legislation as well, so there's still much to be figured out on this front. Once again, that was attorney Scott Schaefers. He is with Cypher Shaw, and for more of his insight on this topic and from insight from his colleagues as well, be sure to visit tradesecretslaw.com. Thanks for joining me today, Scott.
Thanks, Colin.